You've already heard that the Supreme Court eliminated permit systems. What you haven't heard is what came after. And what came after is the decision that alters everything for good. The instant Carson v. United States abolished permit requirements, something entirely expected occurred. California, Illinois, New York, Massachusetts, New Jersey, and Hawaii refused to accept the ruling. They accepted the language. They discarded the term permit. By the close of this video, you'll understand every implication with concrete examples. So let's dive in. Then they swapped it for something different. California branded it the Firearm Responsibility Certification. Illinois labeled it the Responsible Citizen Firearm Registry. York named it the Community Safety Firearms Enrollment. Distinct titles, identical system, identical fees, identical waiting periods, identical government bureaucrats determining who may exercise a constitutional right. For 6 weeks, millions of firearm owners were informed the previous system was dead, yet the replacement system was compulsory. That concluded on June 10, 2026, when Judge Terry Doty in the Western District of Louisiana handed down a nationwide injunction in Anderson-Vibbont that halted every replacement framework in every state and set the legal benchmark that permanently establishes what states may and may not do now that permits have vanished. Hit subscribe immediately, because Anderson-Vibbont holds the precise legal standard that decides whether your state's replacement framework is constitutional or unlawful, and directly impacts whether you must obey the new system states are constructing to replace the permits they just forfeited. Gun rights lawyer Mark Anderson, working alongside the Firearms Policy Coalition, filed in the Western District of Louisiana before Judge Doughty, Trump appointee, who had earlier delivered major nationwide injunctions on constitutional matters. Anderson's petition argued that all 6 replacement frameworks were facially unconstitutional since they accomplished precisely what Carson barred, merely beneath altered terminology. Judge Doughty concurred, granted a preliminary nationwide injunction within 2 weeks, and authored an opinion already regarded as the most significant lower court Second Amendment ruling since Bruin itself. Allow me to guide you through the legal standard. Doughty laid out what the 6 frameworks specifically attempted, why they collapsed, what states may lawfully implement going forward, and what this signifies for your everyday existence at this moment. Number 1. Doughty standard that now controls all firearm regulations, the substance over form doctrine. Judge Doughty constructed his opinion on a concept drawn from tax law and administrative law. Substance dominates over form. It is irrelevant what title you assign a system. What matters is what the system accomplishes. If a regulatory framework demands a citizen-secure government clearance prior to exercising a constitutional right, that framework constitutes a prior restraint. No matter whether the clearance document is labeled a permit, a certification, a registration, a registry enrollment, or a community safety credential. Doughty penned, states are forbidden from executing end runs around Supreme Court rulings by rebranding prohibited frameworks and reissuing them beneath fresh letterhead. Carson determined that prior clearance requirements violate the Second Amendment. Any framework that demands a citizen obtain government authorization before acquiring, possessing, or transporting a firearm constitutes a prior clearance system within the meaning of Carson, regardless of the label the state affixes to the authorization document. The 4-component standard. Doughty crafted a 4-component standard for whether a state firearm regulation withstands Carson. First, does it demand government clearance prior to exercising the right? Second, does it entail government discretion in granting or withholding clearance, even nominally? Third, does it levy fees, waiting periods, or processing durations before the right may be exercised? Fourth, does it generate a government registry of who has been cleared to exercise the right? If a state framework answers affirmatively to any of these 4 inquiries, it is presumptively unconstitutional as a prior restraint under Carson. The burden then shifts completely to the state to prove the restriction aligns with the historically rooted exceptions that Bruin and Carson retained. What endures the standard? Instant point-of-sale background checks endure since they impose no prior clearance, demand no government-issued document, create no persistent registry of rights holders, and impose no discretionary gatekeeping. Prohibited person statutes endure since they constrain specific identified persons based on specific adjudicated facts, not the general populace seeking to exercise rights. Sensitive places limitations endure since they restrict where rights are exercised, not whether rights may be exercised whatsoever. Number 2. What the 6 replacement frameworks attempted and why they collapsed. California's Firearm Responsibility Certification (FRC) 8-hour state state-sanctioned safety course, $150 to $300. Application with background check, $75. Fee certification card valid 5 years, presented at point of purchase. Failed every component. Demands government clearance. Entails state discretion. State determines which courses satisfy. Levies fees and waiting periods. Creates registry, struck down completely. Illinois Responsible Citizen Firearm Registry. PAR-CE direct substitute for the FOID card. Identical application, identical fee, identical photograph, identical processing duration, altered title. Dowdy characterized it as the most transparent effort to swap form for substance, hate, and an act of deliberate defiance of the Supreme Court's explicit holding, struck down New York's community safety firearms enrollment. CSF State Registry enrollment, character references. Social media examination, $200 fee, theoretically automatic for those who passed. Yet social media and character reference demands gave officials discretion to deny, failed. Every component struck down: Massachusetts, New Jersey, Hawaii. Comparable frameworks with slight variations, all demanded some form of government clearance, document before purchase or carry. All failed the Dowdy standard, all struck down within the same nationwide injunction. Number 3, what states may lawfully implement, and what gun owners must monitor absent prior clearance. Several states are testing training requirements, enforced after the fact through civil penalty rather than before the fact through prior clearance. You may acquire and transport without finishing training, but incur fines if apprehended without a training certificate. Dowdy did not rule on this category of framework. Legal authorities are divided. Some argue any compulsory training burden is unconstitutional. Others argue post-acquisition mandates differ from pre-acquisition permits. This issue is advancing to circuit courts and ultimately back to the Supreme Court. Liability insurance mandates. 3 states are attempting to mandate liability insurance enforceable through civil penalty after the fact. Once more, Dowdy did not tackle this. Whether an ongoing financial condition on rights-bearing is constitutionally equivalent to prior clearance remains unresolved. Enhanced point-of-sale background checks. States may mandate dealers execute state-specific checks in addition to federal NICS, provided those checks are instant or near instant, and yield no document state check consuming 5 minutes with no certification likely. Constitutional state check, consuming 7, yielding a certificate waiting period plus clearance document, both barred sensitive places. Expansion states are aggressively broadening sensitive places lists to hospitals, libraries, parks, entertainment venues, and transit systems, effectively reconstituting permit-free carry restrictions. Geographically, the Dowdy opinion explicitly cautioned against this, noting sensitive places classifications cannot reconstitute what permit systems achieved administratively. Number 4, what the nationwide injunction signifies and how long it remains. Immediate effect. As of June 10, 2026, the nationwide injunction bars enforcement of California's FRC, Illinois RCFR, New York's CSF, Massachusetts, New Jersey's, and Hawaii's frameworks. If informed you must enroll in or obey any replacement system, you need not. The injunction is enforce what follows. California appeals to 9th Circuit, Illinois to 7th, New York to 2nd. The circuits will likely divide. If they do, the case returns to Supreme Court, likely for October 2027. Until then, the nationwide injunction from Dowdy governs new frameworks still covered. The injunction encompasses all state frameworks satisfying the 4-component standard, not merely the 6 named. If a state devises a new system, while this injunction stands, anyone subject to it may file immediately for emergency enforcement. The injunction effectively bars any prior clearance system, states not yet challenged. Several states with existing frameworks are quietly halting enforcement rather than risk being appended to the injunction. If your state operates a framework satisfying the 4-component standard and has not yet been challenged, reach out to the Firearms Policy Coalition immediately. They are coordinating challenges across the nation. Number 5, your complete action plan beginning today. If you reside in California, Illinois, New York, Massachusetts, New Jersey, or Hawaii, you need not enroll in, pay for, or obey any replacement firearm certification, registry, or enrollment scheme as of June 10, 2026. The injunction bars enforcement if any dealer, officer, or state official claims the new system remains required. They are either misinformed or defying the injunction. Document the interaction in writing and reach out to the Firearms Policy Coalition at fpc.org. Their attorneys manage injunction enforcement matters directly. If you already remitted fees, document your payment. Civil rights attorneys are coordinating class action suits, pursuing refunds of fees paid to unconstitutional replacement frameworks. Your receipts serve as evidence. If you operate as a dealer, your obligation is NICS background check, plus any state check that yields no approval document with waiting period. You cannot demand customers present FRC cards for enrollment documents or CSF credentials. Dealers who decline citing suspended replacement frameworks face civil liability. the Dowdy 4-component standard when your state announces a new system. Ask immediately, does it demand government clearance before exercising the right? Does it entail any government discretion? Does it levy fees or waiting periods? Does it generate a registry of rights holders? Any affirmative means presumptively unconstitutional challenge immediately through FPC, SA or GOA construct your legal support network. Join Firearms Policy Coalition at fpc.org, Second Amendment Foundation at s.org, and Gun Owners of America at gunowners.org. Your membership finances every challenge to every replacement framework. Know what remains required. Federal NICS background check at licensed dealers. Age requirements under federal law. Prohibition for prohibited persons. Compliance with genuinely sensitive places. Restrictions at schools, courthouses, government buildings. Safe storage statutes that apply after acquisition, rather than as prior clearance conditions. These endure everything demanding government permission before you exercise the right does not. Bottom line on Anderson versus Bonta, June 10, 2026.